So let's have a real talk about stand your ground. And I'm going to use the Karmelo Anthony case as one example, among others, of how complicated this law can be. Texas is one of the most defense-friendly states in the country when it comes to using force to protect yourself. You have absolutely no duty to retreat. It's a legal framework built around the idea that you shouldn't have to run. Karmelo Anthony built his entire defense on that framework, and the jury didn't just reject his self-defense claim, they rejected the lesser version of it too. So what does this all mean? Hi, I'm Melba Pearson, also known as the Resident Legal Diva. Make sure to comment and subscribe to my YouTube and Substack channels where I do deeper dives into law and real life. In this case, Karmelo Anthony never testified. Not at the guilt phase, not at sentencing. His defense rested on the theory that Austin Metcalf shelved him first, and that Anthony, who the defense noted was physically smaller than Metcalf, feared for his safety and responded by stabbing him once in the chest with a pocket knife. Prosecutors counted directly, you don't get to meet a shove with a stab, especially if you provoke a shove. The jury deliberated about 3 hours and convicted Anthony of murder, rejecting the self-defense claim outright. Boom, gone, right? It didn't stop there. During sentencing, the state agreed to let the jury also consider sudden passion, which is a separate legal question that, if the jury had found it, would have dropped the sentencing range from 5 to 99 years down to 2 to 20. The jury rejected that too and sentenced Anthony to 35 years. So, let's talk about the law behind all of this. Texas self-defense law is what's called a confession and avoidance defense. The defendant admits to the underlying act, here the stabbing, but argues the law justified it. So under Texas Penal Code, a person is generally justified in using force, including deadly force, if they reasonably believe it's immediately necessary to protect themselves. And Texas law does not require a person to retreat first if they're somewhere they're legally allowed to be and not engaged in criminal activity. That's the whole no duty to retreat piece that people mean when they invoke stand your ground. However, that protection has a built-in limit, and that is provocation. So basically, don't start, none won't be none. If you're the one who starts or escalates the confrontation, Texas law could be like, whoop, take away your right to claim self-defense for what happens next. That's the legal hook behind the prosecutor's line about the provoking a shove. It was aimed directly at the defense's legal justification at its foundation. Here's where the law gets harder to separate from who's judging it. Self-defense doesn't just ask what happened. It asks whether the defendant's fear was objectively reasonable. Reasonable is not a fixed legal number. It's whatever the jury decides a reasonable person would have felt in that situation. On paper, that standard is completely race neutral. Problem is, it is not race neutral in outcome. And there's real data behind that, not just intuition or feeling or anything like that. In 2012, the Tampa Bay Times built the most comprehensive database that exists of stand your ground cases in Florida. And Florida, my home state currently, is the state that pioneered the stand your ground law. And y'all will remember George Zimmerman murdering Trayvon Martin. To this day, I still think it's homicide, but it is what it is. That's what the jury found. I'll leave it there. But that was the case that pretty much brought stand your ground to all of our consciousness, right? Tampa Bay Times, in their initial analysis, found that defendants who kill a black person went free 73% of the time. 73% of the time, compared to 59% when the victim was white. And then a follow-up peer-reviewed study using that same data set, led by researcher Melanie Goodman, controlled for the other case variables, so including whether or not the victim was armed, who was the pursuer, was there a prior relationship between the parties, and still found that a defendant was twice as likely to be convicted if the victim was white than if the victim was not white. Separately, the Urban Institute's John Roman. He analyzed FBI justifiable homicide data nationally. And he found that in stand your ground states, white on black homicides were 354% more likely to be ruled justified than white on white homicides. So the consistent thread across every version of this research isn't the race of the person claiming self-defense. It's the race of the person who ends up dead. Whoever's sphere the law is protecting, it treats a dead black person's life as less likely to require an answer. If you think, okay, you're being abstract, this is history, hold on. I got more, because you know I stay bringing receipts. Columbia, South Carolina. This year, jury acquitted Rick Chow, a convenience store owner, of murder in the 2023 shooting death of 14-year-old Cyrus Carmack Belton. Chow chased the teenager more than 130 yards over a suspected theft of 4 bottles of water and shot him once in the back. A judge had already denied Chow immunity under the state stand your ground law before trial. So prosecutors still had to take the case to the jury, and multiple witnesses said straight up, they testified, they never saw the teenager point a weapon at all during the chase. Jury was like, whatevs, and acquitted him anyway. And right now, in Baker County, Florida, 2 young black men, Jamarian Byrd and Travis Roberts Jr., are fighting first-degree murder charges after a judge denied their own stand your ground immunity request. The judge's order actually found that they were initially entitled to use deadly force, but that entitlement dissolved the moment the other man began retreating, and that they kept firing after the threat had ended. Wait a minute, in the Chow case, kid was running away, they shot him in the back. That was okay. But yeah, okay. I'll let y'all do the math on that one. Right. So the case is ongoing. So the final outcome is not yet decided. We don't have a verdict or anything like that. But the NAACP has already raised questions about how that same disqualifying standard gets applied inconsistently across racial lines. I'm going to leave it there. So that's the real answer to who gets to be a victim here. It's not written into any self-defense statute. It's decided by whoever ends up in the jury box or on the bench. Applying a reasonable person standard that the data shows was never race neutral in application, even when it's race neutral in the text of the law. In closing, Texas built one of the most defendant-friendly self-defense frameworks in the country. And it didn't matter here, because the law only protects you as far as the jury believes your fear is reasonable. And the numbers say whose fear counts as reasonable still heavily depend on who's on the other side of it. So who gets to be a victim in America? That's the question I'm going to leave y'all with. Sound off in the comments. I'm Melba Pearson, also known as the Resident Legal Diva. Stay safe, stay informed, and keep demanding justice. Take care.